Hi, I'm Professor Ann Carlson of the UCLA School of Law, and I'm also the director of UCLA's Environmental Law Center. I'm going to talk today about a very important decision that was just issued by the United States Supreme Court. The United States Supreme Court just handed down a decision, Massachusetts versus EPA, which is its most significant decision to date about global climate change, and in fact maybe the most significant environmental decision the court has ever issued. In the case, the Environmental Protection Agency argued that it does not have the authority to regulate greenhouse gas emissions from automobiles. Those are the emissions that scientists almost uniformly believe are contributing to global climate change. The U.S. Supreme Court rejected the EPA's position. The EPA's position was part of an overall Bush administration position toward climate change regulation. And that's a well-known position. It starts from a premise that the administration is opposed to the idea of any mandatory regulations governing greenhouse gas emissions from all sources, utilities, automobiles, and other large emitters of greenhouse gas emissions. This is just part of a larger strategy that includes withdrawing from the Kyoto Protocol, refusing to endorse anything other than voluntary emissions reductions, placing economic growth above any environmental regulation, and taking a position that the United States will not act to regulate greenhouse gas emissions until large emitters like India and China begin to act. Though the Bush administration's reputation as a laggard on climate change is a deserved one, and the rest of the world is watching and waiting for the United States to act, more quietly, a number of states and cities around the country have begun to take significant action to reduce their own greenhouse gas emissions. California has, not surprisingly, led the effort among the states. And the decision in Massachusetts versus EPA actually may have more effect on California's efforts, at least in the immediate term, than on any regulatory efforts the federal government undertakes over the next several years. Here's why. California has issued regulations to regulate greenhouse gas emissions from automobiles. That's exactly what was at issue in Massachusetts versus EPA. And the state has done so under authority delegated to it by the Clean Air Act, the same statute that the court was considering in Mass versus EPA. California gets that authority even though all 49 other states are prohibited from regulating mobile source emissions. And it used that authority to issue the first greenhouse gas emissions regulations regulating automobiles in the country. So far, another 10 states have indicated that they will follow California's lead, something they're authorized to do, again, by the Clean Air Act. Before California can regulate, however, the Environmental Protection Agency needs to grant the state a waiver from the Clean Air Act provisions otherwise prohibiting California from acting. Prior to the decision being issued by the Supreme Court, the EPA took the same position with respect to California that it took in the litigation in front of the court, and that is that the Clean Air Act does not cover carbon dioxide emissions and therefore that California can't regulate them. The Supreme Court rejected that particular position. EPA now still needs to grant California its waiver, and it may not do so. It may drag its feet or it may deny the waiver altogether. But if it does so, California has already indicated that it will sue, and the decision in Mass versus EPA makes a victory for California much more likely. In addition, California faces other legal challenges that will now be helped by the Supreme Court case. The auto manufacturers, for example, have sued California and other states who have indicated that they will adopt the California standards, again on the same grounds that Massachusetts versus EPA decided, that the Clean Air Act doesn't allow California to regulate carbon emissions. The court rejected that view. The court decision helps California in another legal argument the auto manufacturers are making, that the regulations California issued impermissibly regulate fuel economy, something that's solely within the province of the federal government's legal authority. The court rejected that argument too by saying that it was not inconsistent with the federal government's authority to regulate fuel economy to also issue regulations governing carbon emissions for environmental reasons. So again, Massachusetts versus EPA should make it possible for California's regulations, scheduled to go into effect for model year passenger cars 2009 and thereafter, to go in effect hopefully on time. So the bottom line is this: while the United States and the federal government are doing very little on climate change, Massachusetts versus EPA clears the way for fully a third of the automobile market in the country, that's what's covered by the 10 states and California that are issuing these new regulations, to go ahead and regulate and to begin to reduce the carbon emissions that, again, scientists almost uniformly believe are warming the globe.